Entry 32, and this covers the week of June 8th, 1964. This is a 2-page entry. Tell us how we're starting here, about the first paragraph of this entry.
This entry deals with some of the complications involved in preparing the final report, and I think it's significant that in the first paragraph I refer to a discussion I had with Rankin on Monday of that week, and I said, quote, "I told Mr. Rankin that I thought my function during the next several weeks in the course of preparing the report would probably be to make his life unpleasant. I told him that I did not feel anything should go to the commission unless it measured up to the standards of the two of us and Mr. Redlich. I urged furthermore that no one should be viewed as having final responsibility for any one section, but that for continuity of style as well as quality of the final product, I thought it was important that different portions of the report be written by more than one person." End quote. That seems in retrospect to have been a rather severe and excuse me, somewhat self-centered presentation of my views.
You and Norman Redlich had established quite a partnership by this time. Maybe you could, within the context of what we've just been discussing, maybe tell us a little bit about how you and Redlich worked together so well.
Well, I think it was a close working relationship. I think from the very beginning he was receptive to including me in discussions with Mr. Rankin. I don't think the difference in our age, 6 or 7 years, was importance to him. I thought he valued people sort of on a very straight basis as to what they said, what they thought, what they could do, and what demonstrated skills they had or did not have. So, and Norman was always a very selfless individual in terms of having an open mind for anyone who wanted to express their views. He was very temperate in responding to accusations of favoritism or whatever. He was a terrific colleague and had quite a close relationship with Mr. Rankin, closer as the commission proceeded, and indeed after the commission, a year or so later, Mr. Rankin was appointed to be the Corporation Counsel of the City of New York, supervising a law enforcement agency of 300 to 400 people, and Norman Redlich joined him as his deputy and served in that role for 4 or 6 years, and then assumed the position of Corporation Counsel himself for 2 years before he returned to the law school at NYU. So it was a relationship that obviously continued through the years, and for 8 or 9 months I was part of that, shared with the two of them the responsibilities at the commission. So our writing styles and discipline were the same. We were free to criticize each other's work and to rewrite each other's work. Maybe it was the Yale Law School education, or maybe it was just a matter of personal preferences. But we had very few disagreements. There's a few in the journal where I disagreed with him on some of those inside issues about procedures that we have talked about earlier, and there was later discussions where he argued with Jim Liebler on issues of motive and what should be included in the report and what should not, where I thought on some occasions Jim had the better argument, but in those moments late in September, the arguments did tend to be a little bit more personal and intense than they had been earlier.
Well, you were all probably very tired by this point, I imagine. You talk a little bit in the next couple of paragraphs about reviewing and in some cases rewriting material, but then on the second page we reach something of an explosive moment. There's a quote here I'll read. "On Tuesday there was a discussion between him," meaning Mr. Ball, and Mr. Redlich, which upset Mr. Ball considerably since it appeared that his material was being reworked during his absence. Give us a sense of how contentious this issue became.
Well, it was a very important issue, and it had two aspects to it. First, Joe Ball was a very personable a criminal defense lawyer. He was very successful. He was in his early 60s and was one of the best-known criminal defense lawyers, not just in the West Coast, but in the United States. And he was a close friend of the Chief Justice. So, and he had a very close working relationship with David Bellin, who came to think and expressed vigorously his defense of Joe Ball, both with respect to his achievements and to the drafts that Bellin and Joe Ball collaborated in producing. And one of the issues centered about where the shots from the depository should be treated. And Bellin and Joe Ball had included a discussion of the 3 shots and where they came from and what their impact was as an essential part of the case, so identifying Oswald as the assassin. In reviewing the material, though, it appeared to some of us that the case with respect to Oswald, of course, was depended in part on the shots, but that the shots themselves involved a whole series of separate issues, and particularly the nature of the wounds, the timing, the consequences that followed. And so there was the thought that the discussion of the shots should be enlarged and taken out of the Ball-Bellin material and become a separate chapter. And they argued strongly against it because they thought it was weakening their setting forth of the evidence supporting the finding that Oswald was the assassin. But Rankin and Redlich and I all agreed there should be a separate chapter, and I forget either Norman or I were the original responsibility to try to take the material out and create that initial separate chapter. I think I was asked to do that. But then more broadly, there was the philosophical question that David Bellin and Joe Ball raised about their chapter in draft form defining Oswald as the assassin. They felt, and Joe in particularly emphasized, that the evidentiary case against Oswald was overwhelming in terms of location and eyewitness testimony, the rifle, and his escape, his killing of Tippit, and a fact that often gets lost in discussions of Oswald's culpability. And the two of them wanted to present the matter in a very matter-of-fact way, in the same way it would have be presented in court if it had been a prosecution of Oswald. And as an indication of their focusing on what would have been done in court, they had what's called documentation of what's called the chain of custody with respect to evidentiary material like the rifle, the bullets, the brown sack, and other evidence on site. And because in a real proceeding, a defense attorney would be constantly trying to challenge the integrity of the prosecutor's reliance on a particular piece of evidence. So it was an important element of any defense in court to be able to document that the bullets had never been out of the hands of an appointed custody, and so forth and so on. So the draft included, as I recall, many pages defending the chain of custody, and it occurred to me, and I'm sure to others, that what's appropriate in a court proceeding was just bordered on the irrelevant so far as a report of this kind would need to address. So that was one issue, but even the more important issue to Ball and Bellin was that rather than just set the information forth in a convincing manner, we thought that this chapter about Oswald ought to be elaborated on to counter some of the prevailing challenges to the initial portrait of Oswald as the assassin. And Bellin wrote persuasively in one memo I recall, and may have quoted I think in the book, that we had surrendered to the Lane and Buchanans of the time by trying to rebut their principal challenges to the case against Oswald. And he thought we were being driven by the critics in structuring the chapter rather than in focusing on the affirmative case against Oswald. So there's certainly, that is a legitimate point, but the majority view in the staff, and more importantly Rankin and the Chief Justices, was that we had to, and logically should, expand our discussion of the evidence so that it either overtly or implicitly rebuts important challenges to the so-called case against Oswald. So Ball and Bellin were vigorous in their defense of their approach. Ball continued to be offended by these significant changes in his work product. He undoubtedly thought it was inappropriate for people younger and less experienced than he to edit his materials, and Bellin joined him in that series of complaints. I'm sure he took the opportunity to air his dissatisfaction to the Chief Justice. He may have had some private conversations with Rankin, but Rankin was quite steadfast in his decisions with respect to these elements in the report. And I think he deserves a lot of credit for doing so. And I'm sure he might well have had conversations privately with the Chief Justice, trying to explain to the Chief Justice what was going on so that the Chief Justice wouldn't be put off by what the staff was producing in light of the arguments he was hearing from Joe Ball.
Did Ball ever threaten to walk away?
No, I don't think so. There were some threats to walk away on other subjects by other people, but no one really seriously considered that, I believe. Ball did end up going to California at some point, either late May or June, and I forget whether he came back on occasion. I think he probably did. And some of the controversy about the structure of this chapter was done by exchange of memos between Bellin and me and others.
Now, while this was happening with Mr. Ball and Mr. Bellin, Jack Ruby testified this week in June of 1964. Do you want to talk a little bit about that?
Yes, there's a very interesting story involved in that. Ruby had expressed a desire to be interviewed, but his attorneys were very upset with any possible interview of Ruby. They thought it was not appropriate or fair to interview a defendant who had been convicted and sentenced to death while his appeal was being shaped, including arguments with respect to his mental competency, since that had been an issue raised by his lawyer in the lower court and rejected out of hand by the judge at trial. So there was contacts made with the attorneys who basically of Ruby, I forget whether it was Spector or someone else, and they basically said that because Ruby was not in full command of his senses and may have been impaired mentally, that they could not waive the attorney-client privilege and agree to such an interview. The Chief Justice was determined to have an interview in any event, and in anticipation of that, David Bellin, who was in Dallas to conduct depositions in his own area, happened to contact Rabbi Silverman, who was the rabbi of the synagogue where Ruby was a member. And Rabbi Silverman told David that he was in contact with Ruby, who protested his innocence with respect to this the matter or his motives, and wanted to be interviewed. And so David suggested I guess to be more specific, Ruby wanted a polygraph test and a mechanism of questionable reliability in those ages and today as well. So in discussions with Silverman, David suggested, and this did not become public knowledge for a couple of years, suggested privately to Silverman that he advise his client to request a polygraph when he was interviewed by the Chief Justice. So the Chief Justice appeared with Arlen Specter on a Sunday in May. Although a more elaborate itinerary, including more interviews, had been scheduled by Rankin, the Chief Justice said he had only Sunday because he had to return to hear arguments on Monday. And Specter was there because of relationships he'd established with the Chief Justice, and I think because Bert Griffin was somewhat disabled because of this conflict that had developed between Bruce and a patrolman, Dean, in the police department during a deposition taken. So the two of them came out, and there was a great interest, and people from the various law enforcement agencies were present at the interview. In the course of that interview, Ruby stated, that he had no relationship with Oswald and was not part of any conspiracy, and that he had no conspiracy involved in his killing of Oswald. He did it on impulse, and because he wanted to spare Mrs. Kennedy the need to return to Dallas in the course of any trial of Oswald. So in the course of that interview, Ruby did ask for a polygraph exam, and in prompt response, the Chief Justice more or less said, "If that's what you want, I'll arrange it." And on the way back in the plane, he expressed to Arlen his regret now that he had made such a commitment, because he knew that the mechanism was not reliable, and that he and the commission might be accordingly criticized for even pretending to depend on such a frail instrument of testing Ruby's intelligence and integrity. And as I report in the book, Arlen was not accustomed to giving direction to Chief Justices, but on this occasion told Chief Justice Warren that under the circumstances, you really have no chance but to go forward, right. No option but to go forward with this proposal to use the polygraph. So there then resulted an extended debate with the FBI back in Washington, with Rankin and other members of the staff weighing in as to the propriety of this. But the Chief Justice agreed to go forward with it, and the FBI reluctantly agreed to make available its examiner to do the actual work. And so I forget whether it was 2 or 3 or 4 weeks later, the Chief Justice, I don't think the Chief Justice came back, but Arlen came back to conduct the interrogation of Ruby with the polygraph examiner there to apply the technology to ascertain whether he was telling the truth. So there was an enormous conflict about who should be present at the meeting. Arlen did not want to have another a capable polygraph examiner in the room, and that's who the district attorney wanted to put in the room. So there was the threat of canceling the appointment and otherwise going to court. And Arlen eventually backed off slightly, as did the district attorney, to permit the interrogation to go forward with someone else in the room from the district attorney's office other than another polygraph examiner. And so the transcript of both interviews, of course, is among the commission's materials. They make very interesting reading, in my opinion. And Ruby answered most questions asked. He did not ask a few questions that pertain to threats to his family and some personal matters, but otherwise he answered questions put to him by Arlen Specter. And also questions were subsequently asked by psychiatrists that were, I guess, there on behalf of the attorneys, who Arlen thinks were trying to achieve 2 different objectives. First, if they wanted to make sure that if Ruby's polygraph exam suggested that he was telling the truth, then they would use any psychiatrist examination to support Ruby in that regard. But if there was any evidence of dishonesty and demonstrated, then they would try to invalidate it because he was not mentally competent. Mm-hmm. So it was a rather strange mix of motives and efforts, and but the end result was an examination as to which the FBI examiner, who Arlen had great respect for based on his performance, said that he thought Ruby was in fact telling the truth on all the important issues with respect to relationships with Oswald or other conspirators and the circumstances under which he acted to shoot Oswald. Somewhat to my surprise, Hoover overruled his examiner and would not let a finding to that effect, I think, be communicated to the commission officially. Mm. So tell a good story. It's there for the record, and people can make of it what they wish. I think it's a very colorful part of the Ruby investigation, and as you know, eventually he was the verdict was overturned on appeal, right, in part because of the statement. The statement of Dean, and also, I guess, the failure to change venue, yeah, of the trial.
I know we need to move along, but the week of June 8th was very significant because in addition to Ruby, on June 8th, testimony was taken from the District Attorney Henry Wade. And Wade talked about the local investigation of the assassination. He talked about that mob scene at Dallas Police Headquarters that everyone could see on the videotapes. But most importantly, what I want to ask you about is the statements that Wade made to the press, especially after Oswald was shot, sort of laying out the Dallas police case against him because Oswald was deceased at this time. Can you give me a sense about how the commission treated Wade as a witness, considering that he had made these statements which could be considered detrimental to the investigation?
Yes, well, there was in those statements by Wade, of course, that had precipitated and enlarged the concern in Washington of proceedings that would go forward in Dallas. And it was one of the reasons why the commission was appointed. And as you recall, one of the missions Jack Miller had, along with Barefoot Sanders, when he went to Dallas on November 24th or 25th, was to try to persuade Wade to be less verbose on issues of evidentiary nature. So Wade had also, I think, come up with some of the senior Texas lawyers in January with respect to the allegation that Oswald was a paid informant of the FBI. I'm sure Wade was treated with respect. I don't recall whether any one of the commissioners, tried to challenge him with respect to what he had done. I think the commission makes clear to some extent their rejection of his conduct during those few days when Oswald was alive and charged with the murder of the president. Okay. And Wade, of course, went forward to preside over the prosecution of Ruby.
Well, he was DA in Dallas for decades after this happened. All right, we'll go ahead and move on to the next entry.